Let's talk about the big FTC decision on Thursday to block Microsoft's acquisition of Activision Blizzard. Microsoft had announced that it's planned to buy that company for $69 billion, one of the largest acquisitions in tech. But when the deal was announced nearly 1 year ago, the company said it aimed to close that acquisition by next summer. Now, that is all being called into question. Joining us right now is Makan Delrahim, who was the top antitrust enforcer under President Trump. Now he's a partner at Latham & Watkins, and we welcome him to the program. Makan, it's very, very good to see you, especially to have an opportunity to talk about this transaction. I'm very curious what you make of the suit and the effort to block this transaction.
Well, thanks for having me again, Andrew. I think the suit was probably not a surprise for a lot of folks who've been watching the enforcement regime in the last 2 years. I think, there's a greater tolerance for risk by the antitrust enforcers. And, it's one of those rare vertical merger challenges. But it's going to be interesting. I think the FTC has some challenges in market definition in the case. But the timing and the process for these types of cases make the whole effort moot, because I think the trial date that they've asked for sometime in August, which is outside the merger end date, which is, I believe, in June.
You said you thought that this administration has a willingness to take more risk. Mm-hmm. If you were to handicap the way a judge might determine the outcome of this case, how would you, if someone said to you, what are the chances? What are the chances of a win or a loss? What do you think they are?
Well, that's always a foolish endeavor for lawyers to try to handicap. However, this is a process here. This is really important in this case. The FTC has gone before its administrative law judge inside the agency itself, rather than to a Article III court in the district courts where the Justice Department, where we had to go to. So they go before their own administrative law judge. This administrative law judge, or at least the last couple of cases they brought, has ruled against the Federal Trade Commission. This was the Illumina Grail case, as well as the Altria Jewel cases. What's interesting is that you appeal that judge's case, guess to who? The commission itself. And so the commission that voted on this sits on the appeal. And then after that, you go to a federal court of appeals. So, and guess what? In 40 years, the FTC has never lost its appeals of its own decisions. So I think that's what makes it a real challenge for Microsoft and Activision here.
Well, let me ask you this, Makan. One of the things is the prospect of this type of litigation over the entire tech industry has had a chilling effect. In some way, you could argue it is its own form of regulation. But if, in fact, the FTC were to lose this case, it also appears that it might shift and change the balance of how big tech thinks about transactions. It could open up the floodgates, if you will.
Well, you have seen a greater appetite of merging parties challenging the government, both at the Justice Department and at the FTC. The real problem is, will merging parties, does financing fall apart after a period of time, especially given the recent changes in the market? Will the parties stay in to challenge this case? You have, a trial date that's in August. It'll probably take, another 4 or 5 months after that before you have a decision, then an appeal to the commission, then you get to court. So I don't know how many parties will stick together and keep a deal going while they challenge the agencies. The agencies themselves believe that somehow that when parties abandon a transaction, that is the best form of outcome for these. And so I think part of their effort is to create this chilling effect on mergers and acquisitions, right. And they've had that effect.